So let us start this webinar. Um, so feel free to ask questions. Um, feel free to ask questions. If you raise your hand, um, we will unmute you for you to ask your question. This is a very important class. And it's important class because it's going to affect you on a personal level and your career. How so? Why should I care about this class? Because you're going to die someday. So will your client. Your client's going to die. Death is still a trend, believe it or not. People still die. Oh my God, right? What a revelation. People still die. When your homeowner died, when mom and dad pass away, you get a call from the son, the daughter says, hey, please list this property. Sell this house for us. Our mom just passed away and you have been the realtor for our mom, for our dad. You, please list this house. What do you do? What do you do? Mom has 4 children. Which of the 4 would have the power to sign your listing agreement? Which of the 4? Okay. That's what this class is about. Mom died, there are 4 kids. Who has the legal authority to sign your listing agreement? Who has the legal authority to proceed an escrow to sign the grand deed to the new buyer? So let that sink in for a second. When you are selling a house right now, the homeowner's alive, the homeowner signed the grand deed to the buyer, right? When your client is dead, mom is dead, how is mom going to sign the grand deed to the buyer? That's the essence of this class. That's the essence of this class, okay? It's a very simple question, but the answer could take hours, because there's a lot of ins and outs. So I'm going to start. Raise your hand if you have a question, and we will unmute you, and we'll learn from each other. Okay. All right. So the gold standard if you own a house, the gold standard ought to be a trust. Okay. That should be the gold standard, is to put your house in a trust, not a will. Because a will absolutely put you in a probate. It's a guarantee. The word probate is a Latin word. It means to prove the will in a probate court. So what I want you to do is this. You ought to take a picture of the screen. It's a Kodak moment. Pull out your Kodak phone. Yeah, your Kodak phone. Pull out your Kodak phone. Take a picture of the screen. It's like a comparison between a will and a trust. Okay. So what I want to tell you is, I'm going to give you the answer immediately, right? What's the difference between a will and a trust? The will is absolutely going to put you into probate. A will is going to be much more expensive for your children. Why? Because in a will, if you have a will, your son or daughter is going to have to take that will, submit it to the court, and it's going to get probated. Okay, and you do not want to go to probate. You do not want to probate because a probate takes at least a year to do. A probate takes at least 1 year to complete. So for example, let me just show you what a so what I'm going to share with you is on the screen. This is a pretty good Kodak moment as well. It shows you a probate. A probate takes at least 1 year to complete, at least 1 year to complete. So when we ask the question, how is a will different than a trust? In the long run, a will costs your children more money. Why? Because a will put your children into the probate court. If all you have is a will, you're missing other document. Okay? A will takes effect the moment you pass away. Okay? A will takes effect the moment you pass away. Now listen to that sentence carefully. A will takes effect the moment you pass away. Well, a lot of time, we don't just drop dead. A lot of time, we don't just drop dead. Okay? So, because a lot of time, you have dementia, you have Alzheimer's, you have a stroke, you're incapacitated. A will doesn't deal with any of that. So when you go and draft your trust, a good lawyer will accompany that trust. He will give you other legal document to accompany that trust, the durable power of attorney, the advanced healthcare directive, a pourable will. He's going to transfer the house into the trust. Okay. If you have any LLCs, corporation, he will make sure that's in your trust as well. Okay. Let's see here. Okay, so on the screen, you are beginning to see how a will is different than a trust. A trust, when you go draft your trust with a lawyer, it's more comprehensive. It's a more elaborate, comprehensive estate planning. You don't just drop dead. You don't, right? You might have dementia, Alzheimer's, and so forth. If you have Alzheimer's, you're unable to function. That's a problem. Okay? If you're unable to function, that's a problem. It's going to require conservatorship. So what happened is, if you have a trust, it's going to come with a durable power of attorney, where it's going to let your son or daughter sign your name on your behalf. So the example that I normally like to share with you is this. Take a look at this. Take a look at this slide. Take a look at the screen. This screen talks about the durable power of attorney. Imagine this. You're out on a listing appointment. It's a married couple. They want you to sell this house. The husband has dementia. The husband has Alzheimer's. The wife is fine, so the wife signs your listing agreement. But because the husband is incapacitated, he's unable to do so because he's incapacitated. He has dementia. He has Alzheimer's. If you have a durable power of attorney that would accompany the trust, the wife can sign the husband's name, sign your listing agreement. Okay? So as you can see, we are beginning to parse apart the benefits of having a trust-based estate planning versus just having a will. Do you have any questions so far? So we can address it. Raise your hand, guys, and I can unmute you, or you can type in the chat box. It's all up to you. If you have a question, raise your hand, and then we can unmute you. Okay. All right. Yeah. So we have about 30 people online. It's a nice number. Okay. So Katrina asks, can you have a durable power of attorney without a trust? Yes, you can. You can do that. Okay. You can have a durable power of attorney without a trust. You can do that. And that's an interesting question, right? So if someone does not own anything, let's say, for example, if you have a son who's 19 years old, if you have a daughter who's 19 years old, he or she does not own a house. If he or she is incapacitated, he or she gets into a car accident, he or she is in a coma, you are unable to sign his or her name. You're gonna have to go to court to say, hey, judge, my 19-year-old daughter is incapacitated. Give me the ability to sign her name. Let me be her guardian. That's troublesome. That's conservatorship. So even for a young person, 19-year-old, 20-year-old, 21-year-old, 22-year-old, your son, your daughter ought to have a durable power of attorney so that in an emergency, you're able to sign their name and legally be able to take care of them. Okay. Now, going back to when you go get your trust, when you go see a lawyer about getting a living trust, the lawyer, he or she is going to give you these whole entire lists. You say, why is that? Why isn't this an a la carte? Why isn't this where I can choose certain things? Because a good lawyer is going to know you need all these documents. Imagine you go to buy a car. You go to buy a car. You're at a car dealer. And you say, hey, you know what? I'm an excellent driver. I do not need the airbag. Just give me the seatbelt only. I don't need an airbag. I'm such a great driver. Just give me the seatbelt only. You know, that's not how, when you design a product, when you design a service, you design in such a manner where it's complete. Okay. You know, can you imagine you're the listing agent and you say, oh, what, I'm not going to review certain escrow document, you know what I mean? Like, I'm not gonna, you do the RPA yourself, or you review the purchase agreement yourself, or you do the comp yourself. I'll charge you 1% less. It doesn't work that way. Okay. So when you go to a good estate planning attorney, he or she will give you that these complete documents. All right. Yeah, if you have a question, guys, just raise your hand and I will unmute you. Okay. If you don't raise your hand and we blow through these issues, we're gonna probably end soon. Okay. So raise your hand if you have a question. Okay. And also type in the chat box or raise your hand, like, why did you sign up for this class? Why? What was it that you wanted to learn? Okay. Maybe some question for you. You bought the house for $200,000. When you die, the house is worth $1 million. How do you give it to your son or daughter so that if they were to sell it, there's no taxes either? Okay. So anyway, start thinking about why you signed up for this class. Start thinking about you're gonna die one day. How is it all gonna play out, right? Because whatever I'm teaching you, how to sell a house for a deceased homeowner, it's going to apply to you as well. Okay, so going back to this this chart right here. This is a pretty good chart in comparing the difference between a will and a trust. Don't do the will. Here is another issue with a will. In California, people sometimes use Medi-Cal. Okay, people use Medi-Cal. Now, Medi-Cal bill can rack up. Medi-Cal bill can reach 100 grand, 200,000, 300,000. Here's the kicker. Here's the kicker. If you have a will, your son or daughter will have to go to the probate, will have to be in a probate court. And in the probate, the judge is gonna want to ask you to get to notify Medi-Cal, meaning during your lifetime, did you use any Medi-Cal? If you use Medi-Cal and you're in probate, they're gonna make you pay that back. Okay, so how expensive are medical bills these days? If you use Medi-Cal and you have a will, your children will have to pay it back. Sell the house, take the money, pay back Medi-Cal, whatever you used. To avoid Medi-Cal, guys, two simple things to avoid Medi-Cal recovery. Get a trust, so there's no probate and you can die, right? Do it in that order. Okay, so that's another benefit of having a trust. Hey, listen, if you say, I don't care, I'm going to use Medi-Cal, I'm going to have a will, I'm going to rack up $200,000 worth of Medi-Cal bill, and so what, who cares, so sad, too bad, let my children deal with it, fine. But if you don't want your kid to pay Medi-Cal, get a trust. All right, let's see here. So let's see here. So we have a couple of questions in the chat box. So let me take Max first. Max asked, which part of the trust usually miss a lot by mistake? So Max asked the question, which part of the trust? Maybe we can unmute you, Max. Are you able to speak to the microphone, Max? Hey, Max. Good morning.
Hey, good morning.
Hi, yeah, your question, please.
Yes, lots of people have trust, they have a different situation, but usually you see some trust has lots of issue in the future, and you will feel, okay, that part of the trust, maybe it shouldn't be missed, and it missed a lot. So I want to know which part of the trust we should, be focused on, okay, if I have a trust, just double check, do I have that part or not? If not, I should go and, revise that. That's my question. Okay.
Great. So Max asked the question, hey, in a trust, what is important? What is most people miss in a trust? 99% of all trusts out there is missing this. Max, you ready? And 99% of all trusts is missing this. The trust says, when I die, give it to my children. When I die, give 50% to my daughter. When I die, give 50% to my son. That's what the trust says. And it's good and fine. But most trusts miss this. Most trusts miss the part where it says, hey, if my daughter gets a divorce, her husband cannot touch it. Hey, if my son filed bankruptcy, if my son is being chased by creditors, the creditors cannot touch it. Mistake number one. Most trusts don't do that. Most trusts don't have a protected clause to keep the outside world away from their children's inheritance. Mistake number one. Mistake number two is not a multi-generational trust, meaning You have a daughter, whatever goes to your daughter, if she were to pass away, let's give it to your grandchildren. Most trusts don't have that. So those are two big mistakes. Okay. And there are other stuff in there too, like for example, if someone says to your daughter, Max, you have a daughter, a son. Someone goes to the son and says, hey, Max Jr., you don't have to wait till your father pass away. Your father owns a couple of houses worth a couple million. Max Jr., you need some cash. Here's $10,000 cash. Max Jr., why don't you sign a piece of paper to give me 100% of your interest when your dad died? Here's $20,000 cash right now. You take it. Just sign that paper. That's called a spendthrift trust, a spendthrift clause, and it prevent your son or daughter from doing that. Even if your son or daughter took the money, got bamboozled, whatever they sign, inapplicable, invalid. Okay. So and Max, here's another thing. You pass away, the money goes to your son. Your son happens to be on some sort of special needs program from the government. Your son happens to be using some governmental insurance. It's going to disqualify your son because your son is receiving a certain amount of money from your trust. A good trust should be built in where your son or daughter can still continue to receive any governmental benefit, regardless of how much money they're getting from you. Max, is that what you were kind of looking for? Like what kind of mistake, what kind of common mistakes in the trust, Max? Max?
Yes.
Yeah. Any other question from you in that realm? What
No,
makes...
thank you. Thank you.
Okay, good. All right. So and then let's go to Jim. Let me say hi to Jim. Jim, are you able to unmute yourself, Jim? Are you able to do you have a microphone, Jim? Jim? So Jim, Jim, go ahead and let's say hi to you, Jim. Can you speak into your microphone?
Vaccinations underway.
Hi, good morning, Paul.
Hey, Jim.
Yeah, I question. I have a trust listing right now, and one of the parties had passed away years ago, and so the sister was the primary trustee, and she just passed away, and so the successor trustee, which is her younger sister, were selling the house, and the accountant for the sister that's still living and it's the successor trustee told her that she's not going to owe any taxes. And the stepped up basis, I really don't understand how that works. That would preclude her from paying any tax.
Let's talk about it. Let's talk about it. Jim, do you own a house?
Yes, I do.
How much did you buy your house for, Jim?
1979, 96,000.
Okay, how much is it worth now, Jim?
1.2 million.
Great, Jim. You're gonna live another 20 years. I don't know how old you are, but let's assume you're gonna live 20 years.
I hope so.
And when you die, that house goes to your son, your daughter. It's worth 2 million. Okay. So Jim, you bought it for, what'd you say about you bought it for
96.
You bought it for 96. When you die, Jim, it's worth 2 million. Okay. If you have your house in a trust, leave your house in a trust.
There is
when you die.
Straight. So how do you negotiate with a regime like that?
Hey Jim, you should turn off your TV, Jim. Jim, turn off your TV, okay? All right, so let me answer Jim's question. Jim's question is, hey, first of all, I want to share with you a tax concept, not as a step up in basis. Jim bought the house for 96,000. When he dies, worth 2 million. When he died, his son goes and sell the house for 2 million. There's zero capital gain because of something known as a step up in basis. Okay. So that's the rule with the step up in basis. It's a very powerful tax concept. Very, very powerful. This is a Kodak moment. Take a picture of the screen. It explained to you what is the step up basis. The step up basis is it doesn't matter how much it costs you to buy that house. It costs Jim, your colleague, $96,000. He bought that house in 1976. When he died in 2046, his daughter sells it for $2 million. This is step up in basis, zero capital gain for Jim's daughter. Okay. The baby boomers are going to be dying. I guarantee you, we're in the midst of the greatest wealth transfer in history. A lot of baby boomers have a house, have real estate. When they pass it on to their son or their daughter, there's something known as a step up in basis. On the date of death, whatever is the fair market value of that house, that becomes the new cost basis. And if you sell it for that new cost basis, that is in essence a step up basis. That is in essence zero capital gain. Back to Jim. Jim, I'm coming back to you. Jim, so Jim says, I have a client. And my client is telling the trustee that there will not be any capital gain because of the step up in basis. There is a lot of truth to that. Jim, when did that person die, Jim? Can you unmute yourself, Jim? When did that person die, Jim? Jim, I'm back to you. When did that person die? So I can help you answer your question. Jim, when did that person die? Okay.
She passed away in November of last year.
Perfect. So November of last year, how much was the market value of that house in November of last year?
She had an appraisal done, and it was $1,036,000.
Okay, 1036. How much do you think you're gonna sell this house for? Just ballpark it, estimate only. How much?
1 million.
Jim, on the date of death, the step up basis, the cost basis is 1,036,000. You sell it for $1 million, zero capital gain. That accountant is correct, Jim, because of the step up in basis.
Great. Thank you for clarifying this.
You are welcome.
Could I ask you one more quick question?
Absolutely, Jim. Go ahead.
I've had a trust since 2003. And do you provide a service where you would review that trust to make sure that I'm still where I need to be as far as legal documents and it's updated according to changes in law?
Okay, yeah. So you did the trust in 2003?
Yes, sir.
Yeah, and there's been no changes, Jim, in the last 22 years. There's absolutely no law changes, no president changes, nothing, Jim.
Okay, so don't need to have.
I'm just kidding. I mean, a lot has gone on the last 23 years. Yeah. The iPhone didn't exist. Zoom didn't exist 23 years ago. But yeah, you should. Let's take a look at your trust. Yes, definitely. Yeah.
So just call your office to set up an appointment?
Yeah. What we should do is this, Jim. What we should do is this, and for all of you out there, what I want to give you is this. I want to give you, all of you, a video, okay, on this concept of how do you pass your house to your children tax-free. What you see on the screen is a great video that I have. Let me share that video with you. I'm going to put that into the chat box for everybody. Okay, so if you click on what I put in the chat box, it'll take you to what you see on the screen. Okay, And it's going to walk you through the step up and basis. It's going to walk you through what makes up a good trust. What are the current law at the moment? Okay. Yeah. Okay. So Jim, watch that video. That's my website. It's got all my information as well. Okay. All right. So Katrina says, but if Jim sells the house for 1.1, there would be a capital gain based on 64,000, right? So Katrina says, hey, Paul, stop, Paul. When mom died, the valuation on the day of death was 1,036,000. But what if Jim sells it for 1.1 million? Is there a $64,000 capital gain? Katrina's correct. It's a $64,000 capital gain. Katrina Crawford, how much you think the commission is? I don't know, 5% from both sides. That's 50 grand. How much you think the title fee, closing escrow, and all that? So it's gonna wipe out that 64,000, Katrina. That's a good catch, Katrina. But in your example, most likely no capital gain because of the selling cost, escrow fee, title fee, commission is gonna wipe that out. Katrina, does that answer your question? Katrina Crawford? Yeah. All right. So, yeah, guys, these are great questions. If you have a question, raise your hand and I will unmute you and to ask your question. What you ought to be thinking right now is your situation. You have a house. What is the best way? What is the best way to avoid probate? What is the best way to give my house to my kid? I have 4 kids. It's going to be divided equally, 25% each. Okay, you need to choose one person to be in charge as successor trustee. So the first thing you ought to do, gang, when you are faced with a potential listing, someone passed away, and you get that phone call, the first thing you ought to do is this. The first thing you ought to do is you should ask your title rep to give you the grand deed. Someone passed away, you're the listing agent. The first thing you ought to do is pull up the grand deed. This is also a Kodak moment. Pull out your Kodak phone, take a picture of this. You're the realtor, you get a phone call, someone passed away. You get the address. You're gonna want to see the grand deed. Where do you get the grand deed? You get it from your title rep. When you get the grand deed, it's gonna tell you if the house is in a trust or not, okay? If the house is in a trust, hallelujah, we're good, no probate needed. If the house is not in a trust, that's when you can have a probate. If the house is in a trust, who has the legal authority to sign your listing agreement? Mom died. Mom has 4 children. The house is in a trust. Which of the 4 children have the power to sign your listing agreement? It's going to be the successor trustee. When you go draft your trust, you will be the initial trustee. When you pass away, there's someone known as a successor trustee that's documented in the trust. And that individual is the one person where the title company will want to see the signature on the new grand deed, on the listing agreement, and so forth. Okay, so very, very important. If the house is in the trust, you want to get a copy of the trust because it identifies who is the successor trustee. Hi, Jacqueline. Jackson, good morning.
Good morning. Thank you.
Sure.
Okay, so my question was, there's a property, but it's in the trust for the bank, U.S. Bank, cottage, something to that effect on the title. But when I call U.S. Bank to find out who actually owns the property, because I have a client trying to get that particular property. Nobody knows. They said it depends on if it's being held in a trust. I mean, if we're holding it in a trust. So I've been running up against a brick wall trying to get that figured out.
Okay, who died?
Apparently, the previous owner died. Some years ago, before this, my client's grandmother lived there. I guess the house sold, somebody else bought it. It's been vacant for years. The person who owned it died. So apparently it went to the bank trust. This is my first time dealing with this.
Stop. So when you pull the grandee shows who is the owner right now, per the grandee.
Now that's what I need to do is pull the grand deed. I just pulled the title.
Yeah, pull the grandee. The
Okay,
grandee is gonna show which trust it's in. Okay,
got it.
Jacqueline Jackson, when you go and get your trust done, you own a house. Jacqueline, when we draft your trust, we're gonna redo your grandee, Jacqueline Jackson. The owner of your house, Jacqueline, is gonna be the Jacqueline Jackson Revocable Living Trust. That's gonna be the new owner. That's the mechanic of how vesting is done for a house that's moved into a trust. So when I draft your trust, Jacqueline Jackson, the new owner of this house, on the grand deed, it's gonna say Jacqueline Jackson, comma, trustee of the Jacqueline Jackson Revocable Living Trust, dated June 27, 2025. For example, if you were signing the trust today. That's how we get a house into a trust. Jacqueline,
Yes,
does that help you shed a little bit of light, the procedure of how a trust goes about, how a trust becomes the owner of a house? So I gave you an example of your particular situation. If you went and got a trust drafted, Jacqueline, the new owner is going to be Jacqueline Jackson, trustee of the Jacqueline Jackson Revocable Living Trust, dated, for example, June 27, 2025. Jacqueline.
okay, so for my other issue that I'm dealing with my client, where the title says it's U.S. Bank Cottage, I don't know, something else, I can't remember. But in any case, they said that's considered to be a trust.
Jacqueline, are you dealing with a family member, or are you dealing with a potential buyer who wants to buy that house?
Buyer who wants to buy that house.
Yeah,
Yep.
you're just working way too hard. You have your buyer, you knock the door, next door neighbor, hey, who's the cousin, who's a relative, who's the son or the daughter of this house? And get to the son or daughter, the relative of that house. They would know.
Okay, okay. I think we exhausted all of those ways of going about it, but I'm going to go. I was told to just go to the county recorder, so maybe I'll do what you suggested, which is pull the deed and trust.
Yes, but
Okay,
that house, Jacqueline, is owned by somebody. That somebody, Jacqueline, has a son or a daughter. That somebody has no son or daughter, fine. That somebody has a brother and sister. Oh, brother and sister are dead, fine. That somebody has a nieces or nephew. You know, that person came from somewhere. And whoever the relative is, when it's all said and done, that relative has the power to sell this house to your client, Jacqueline.
okay. All right, well, I'll keep researching. I'll pull that grant and see the grant deed and see what it says.
Okay.
Thank you so much.
Have you talked to the next door neighbor?
I haven't talked to the next door neighbor, but I can ask my client because I'm not in that area. I'm in Southern California. She's in Northern California. So, and I'm familiar with trust because I have one for my own property. I just never saw that a bank had a trust, and I had to look that up.
Yeah, you gotta pull the grandee first and see what's
Okay,
going on. Yeah, yeah, yeah. Okay.
thank you.
You're welcome. So you're in Northern California? No, you're in Southern California. You're Oak.
Yes, I'm in Southern California. I have a lot of clients. I'm from the Bay Area, so I have a lot of clients up there as well. And our office is able to work dual, from San Francisco to the Bay. I mean, LA.
I see. Okay. All right. Very good. Good luck in that.
Thank you.
You're welcome. We have a question from Tina Vo. Tina Vo asked a question. I have a condo and it's in my trust. If I sell it now, do I have to pay the capital gain on it? The answer is yes, Tina. Okay, Tina, do not get confused. The step-up basis, only apply when you die. So your colleague, Tina Vo, asked a question in the question and answer. Her question is, she owns a condo. If she's still alive, right? She's still alive. She's typing in the chat box. She's still alive. If she sells it now, does she pay any capital gain? The answer is yes. But Tina Vo, if you live there, Tina Vo, if you live there, it's your primary resident, you get the $250,000 exemption, 250 exemption. Okay, $250,000 exemption. Okay. All right. Okay. Any other question, guys? Raise your hand, and I will come and unmute you. Okay. So I think there's 3 video that you want to watch that's gonna summarize this class. Okay. Oh, let's see. Let me put in the 3 video for you. So that's the first video. After today, watch that first video. The second video that I would say is going to summarize this topic is this. On the screen, it's a video. On the screen, when you go buy a house, escrow is going to ask you, how do you want to take title? On the screen, you see the various form of ownership: joint tenant, tenant in common, community property. What's the difference? LLC, it's in a trust. What's the difference? Okay. So let me put this, because each way you take title has a legal implication, has a tax implication. So that is the second video that you should watch. Okay, that you should watch later. That's the second video. I'm gonna give you the third video. Okay, I'm gonna give you the third video, and this third video is kind of a bonus hidden video. It's a hidden video. What I want to and I think it's a great video that's gonna outline, if you find yourself in the probate process, what is it like? How much does it cost? And all that good stuff. So what I'm going to do is this. I'm going to share with you. I'm going to put in the chat box. I'm going to put in the third video linked. Okay, I'm going to put in the third video linked. You can review these video on your own, these 3 videos. These 3 video is going to encapsulate, it's going to summarize today's topic. You own a house. How do you smoothly transition this house to your son, your daughter, without going to court? Do you use a trust or do you use a will? You're selling a house. If someone has a will, what's the process? If someone has a trust, what's the process? These 3 videos going to outline it for you. Okay. All right. There are some questions. Let me go get them. Let's see here. Yeah. Tina, are you able to unmute yourself, Tina? Can I unmute you? Can you speak into the mic, Tina, so I can answer your question? Talking to the microphone, Tina Vo, so we can all hear your question. Okay, guys. Yeah, Tina, if you can speak into your mic, so we can all hear your question. All right, guys. Does anybody else have a question that you want me to address? If not, I'm gonna sign off. Okay. Anybody have a question for me? Raise your hand. Let's see, Jacqueline. I think your question has been answered, right, Jacqueline?
That one has, but I was just curious about the other question that was asked earlier previously when he sold the house for $1 million, and she said that if he would have sold it for higher, he would have to pay the taxes on it. And I wanted to find out, is there a certain amount?
No, Jacqueline. How much did you buy your house for, Jacqueline?
I purchased my house for $165,000.
Perfect. And what is the value right now, Jacqueline?
Well, it's probably about 750.
Great. Jacqueline bought her house for, let's just make the math simple. She bought it for 200,000. Now it's worth 700,000 right now. Jacqueline's gonna live another 30 years. When she died, that house is worth 2 million. Jacqueline, you bought it for 200,000. When you die, it's worth 2 million. When you die, so let's just back up. Jacqueline, if you were to sell your house right now, you only pay, call it 200,000. When you sell it for 5, your capital gain, your profit is 500,000. You don't sell it, you put it into a trust. When you die, 30 years later, it's worth 2 million. If your son or daughter sells it for 2 million, there's a step up in basis, 0 capital gain. Jacqueline, your son or daughter don't sell it. Your son or daughter lives there for another 5 years and sell it for 2.5, for example. Your son or daughter don't sell it. They keep it and rent it out for another 5 years and sell it for 2.5 million. The capital gain is only 500,000. Jacqueline, do you see how the math kind of work out there?
Yeah. Okay.
You bought the house only for 200,000. When you die, it's worth 2 million. So if your son or daughter sells it for 2 million, 0 capital gain. Your son or daughter decides to hold on to the property and later sell it for 2.5, we pick up where the $2 million is. So it's 2.5 minus 2 million.
Hello.
Got it.
Yes.
Okay,
Hey,
thank you.
Katrina.
Yes.
Yes, hi.
Yes. Do you want me to speak my question now?
Yes.
Okay. Okay. My sister and her husband have a house, and what happens if he dies and he has a will naming his children as beneficiaries? Can he do that?
So your sister and her husband, do they have the same
They
children?
don't have a trust set up.
Stop. Do they have the same children? Meaning, is it mutual children or is it a blended family where it's his kid from a prior marriage?
His kid from previous marriage.
Oh, okay. All right. Great question. What is your name?
My name is Tina Vo.
Tina Vo. Okay. Tina Vo was asked this question. Tina Vo says, hey, her question is, hey, oh, let's see here. Okay. I have a slide for Tina Vo. Tina Vo says, my sister is in a blended family relationship. My sister is married, and my sister's husband has
A will.
a will, and the will name his children as the beneficiary.
Right.
And so, okay, so do they own a house together?
Yes.
Okay. Tina Vo. You should
But can he set up a will without her name?
stop.
Oh,
Tina
I'm
Vo,
sorry.
Tina Vo. What you're gonna do, Tina Vo, is you're going to pull the grand deed on that house.
Oh, okay.
When you pull the grand deed on that house, Tina Vo,
Yes.
how do you think title is vested? It's gonna be joint tenant or community property, or is it community property without survivorship? Which one do you think is in, Tina Vo?
Joint tenancy.
How do you know that?
Well, oh, I just go on online, on Realist, and I
Do
pull.
you have the grand deed in front of you that shows joint tenant?
Oh, no,
Sure.
I do not have it.
Tina Vo, if the
Yes.
grand deed shows joint tenant,
Mhm.
if he died first, it all goes to her, period.
Oh,
If
okay.
it's joint tenant. But Tina Vo, you have to call up the title company. Hey, title company, could you please give me the address to 123 Shaky Marriage, Main
Mhm.
Street, Laguna the Hill? You know?
Yeah.
You had, so if you get the grand deed
Mhm.
and it says joint tenant,
Mhm.
if your sister died first, too bad, so sad, the house goes to you, her husband.
Mhm.
Her husband died first, the house goes to your sister. The
Okay.
will doesn't matter if it's under joint tenant.
Oh, okay.
But Tina Vo, don't get so happy. What if your sister died first?
Oh, okay. I see.
Right?
Yes.
So tell your sister, don't die first. Next.
Okay.
If the house is under community property, then the will is valid. He can give half of his stuff away
Oh.
if it's under community property.
Oh.
If the house is under community property or as a survivorship on the third column, doesn't matter. It's the
Oh.
I love you way of holding title. It's going to go to the survivor.
Okay. Okay. Got it.
Why don't they get a trust, Tina Vo? Why don't they go see a lawyer?
That's what I'm going to talk to them to see you, Paul.
Talk to a lawyer, have no misunderstanding. Darling, when
Okay.
I die, my stepchildren will not fight with you because you get this house or you get to live there until you die, and then it goes to my children. Whatever their agreement is, Tina Vo.
His purpose is to leave his half to his children.
Does your sister have any children?
No.
Okay. All right. Yeah, we can work it out. But let's do the talking while they are alive. Tell them that when they're dead, it's super hard to talk, Tina, when they're dead.
Okay.
It's not funny, Tina, when you die, it's hard to talk.
I know his son is an attorney.
Yeah. So anyway, just Tina, World War III starts between stepchildren and stepmom. Okay, that's when World War III starts, Tina.
Right.
Okay.
Okay. Thank you so much.
All right. So Monica asked, how much does a trust cost? A good trust is going to cost you about $4,000. Monica, that's what a good trust is going to cost. Yeah. And let's see here. Yeah. So that's it, guys. That's it. Let's see here. Jim asked the question: is there a specific time to get an appraisal after the trustee passed away? Do it, I would say, a month or two, but do it ASAP. Guys, I want to thank OCAR. I want to thank Elsa. Everybody if you enjoyed this webinar, give Elsa a shout out at OCAR. She is terrific. She's the one that dragged me out of bed to do this webinar. Give her a shout out. If you enjoyed it, if you got good information, give OCAR a thank you, give Elsa a thank you. Other than that, guys, have an amazing weekend. And I want to thank all of you for being here with me. Okay, watch those 3 videos that I sent you that was in the chat box. Watch those 3 videos. Okay, watch those 3 videos. Thank you very much, guys. I'm signing off. Bye-bye.